Thank you. So what we have is a motion to dismiss filed by the Workforce Commission, and Ms. Bost, you will go on that motion, and then we are limited with time. Everybody is limited to 30 minutes today, so 15 minutes at most, and you may proceed.
All right, thank you, Your Honor. The case before you today has already been heard and dismissed in cause number D1GN 24009532. A hearing on TWC's plea to the jurisdiction was held on January 24th, 2025. Ms. Lee appeared at that hearing. She gave oral testimony, and there was a record that was made of that testimony. On January 31st, 2025, Judge Mangrum signed an order dismissing that cause with prejudice. Ms. Lee did not file an appeal of that decision, but instead filed a brand new lawsuit, the one before us today. Ms. Lee alleges the same causes of action, and the parties are the same as the one previously dismissed. Again, in this action, as she did in the prior, Ms. Lee alleges intentional torts against the TWC's prior plea to the jurisdiction addressed those causes. Intentional torts are not actionable against a governmental entity such as TWC. Sovereign immunity bars such actions, nor did TWC waive its sovereign immunity. Ms. Lee was unable to prove through any evidence submitted through oral testimony that these actions were, that intentional tort is actionable against the TWC, nor did she prove that TWC waived its sovereign immunity. Additionally, TWC's plea addressed the fact that the underlying administrative decision was moot. Employment benefits, she received those monies. The court has authority to review an administrative decision to possibly push it back to the administrative phase, but not to award monetary relief to a plaintiff concerning an administrative decision, which is what Ms. Lee is asking for in this case, and in the prior, she's asking for monetary relief. But the decision is moot, and it's moot in her favor because she was awarded those benefits. Because this case concerns the same causes of action, intentional torts, specifically, she talks about sabotage, defamation of character. In this case and in the prior, those are not actionable against the TWC. Sovereign immunity bars such actions, and also the parties are the same. So we ask that this case also be dismissed. This claim is precluded in its entirety. It has already been decided by order signed January 31st, 2025.
This is where the legal wall comes crashing down. The state's attorney makes it brutally clear. You already got your benefits. Your case was dismissed, and the government can't even be sued for this. Sovereign immunity, that's the legal shield government agencies use to block lawsuits. For Miss Lee, it sounds like the door is slammed shut before she even gets to speak.
Response, Ms. Lee.
Hello. I have a grievance with that dismissal. That dismissal was done within a period of maybe 4 days. At the same time, my evidence was never submitted. It started out with a miscommunication concerning Ms. Bose. She never gave me the Zoom link, withheld all the information that I needed in order. She basically did not let me know the information. The whole entire case, when we spoke on it, on the hearing, I basically told what was going on with the situation where I was sabotaged over a period of 2.5 years. It's an exceedingly long process for appeals. I was told appeals only last like 6 weeks. So between 2 appeals, that was a 2-year period. I was not notified for either appeal, even though I was emailing them, calling them. They were corresponding back with me. I received an email from executive staff telling me to wait and hear from the hearing. Never heard anything from anyone, and then they just had the hearing out of the blue, not even notifying me, but they had my email to contact me on the 12th. They had the hearing on the 19th. So that was an infraction. And then Robert, clear all the way up until the day before the second hearing, I was calling and asking him for the information. He said he was sending me a packet. I told him just give me the information for the hearing so that I can attend. He did not do that. So I ended up missing the second hearing. I had to get in contact with Governor Greg Abbott in order to get this pushed. Greg Abbott got in contact with TWC. Next thing you know, we have the third hearing, which is at this point is 2.5 years, over a decision that was given to TWC from Goodwill, which was a wrongful decision. And it basically got me denied. But in the end, we found out that I was.
Listen to the frustration here. Miss Lee is not just talking about paperwork. She's talking about years of her life wasted. Imagine waiting 2.5 years for justice, only to find out hearings happened without you, links weren't sent, and appeals dragged on endlessly. She feels sabotaged, like the system itself worked against her.
I think it's Judge Mangrum that you're referring to. I think you're calling her Miss Mangrum, and it's Judge Mangrum. But I also wanted to state there was a moment ago where we lost your sound for a minute, and you kind of garbled. And so the only thing that Ms. Racanelli will be able to take down when that happened, it wasn't substantive, I don't think. I got the gist of it, but she's going to have to put down garbled record or something. If you want to go back about 30 seconds to with what you were saying, because we missed it and I tried to stop you, but my sound didn't cut your sound. So sorry, we just need to go back a little bit.
Okay. Basically, Ms. Both withheld information that I needed for that Zoom. My 14th Amendment was disrespected on the due process. I did not get a due process. I was never able to enter any evidence. Basically, the whole entire meeting was, I told what was going on with TWC and I showed some information, but it was never ever submitted, ever accepted by the courts. When I tried to submit it, I got an ex parte for submitting it wrong because I was not able to submit it to the Zoom meeting because of lack of receiving the Zoom link prior to K. So when I explained that to Judge Mangrum, instead of her citing Ms. Bose for not giving me the information, because when the court sent it to Ms. Bose should have just forwarded that information to me. Instead of forwarding it to me, she sent me a separate email telling me about the email being another wrong email, which at the time I did not have access to that email because that email was in a computer. It was not in my phone. That's the email that I don't even use. It's like a backup email. So how they got the information, I don't know. I'm assuming Ms. Bose gave it at the same time. I was cited. Ms. Bose was never cited or reprimanded for withholding the information. As far as me speaking on this is just the res judica. As soon as Ms. Bose entered that dismissal in as evidence, that gives me a right to speak on it and also defend myself because she submitted it as evidence. So therefore, that's the reason why I'm talking. So really and truly, where this is all concerned, we never discussed anything about my case. I've showed you the thread. I literally sent the whole entire thread. Yes, ma'am, Ms. Bose. I've sent the whole entire thread. We did not discuss anything other than Ms. Bose's issue about the Zoom link and me being late and the fact that she did not give it to me after the hearing was concerned. But like I said, during the hearing, I did try to show some evidence, but like I said, it was never submitted, never accepted, or anything like that. So I feel like since my case was not heard and my information was not discussed and it was not entered, I have a right to reopen another case. That's why the court found it okay for me to do. So therefore, this new case, I want to basically bring up the fact that Ms. Bose withheld information from me. Ms. Mangrum signed off on it. I was cited twice over this misinformation, and nothing was done for Ms. Bose. As far as I would like to press charges in this matter over the.
This is the emotional breaking point. She says she lost her $300,000 home, her car, even family heirlooms. You can feel the raw pain in her voice. All you had to do was make a 5-minute call, and none of this would have happened. Whether or not the law agrees with her, her reality is clear. The process left her devastated.
I'm going to have to mute you because I'm trying to stop you and there's no other way to stop other than to mute you. I'm going to come back to you, but I just want to be clear that one thing we don't allow in court is we don't allow sort of talking to the other participant. You have to talk to me and address your arguments to me and not to Ms. Bost directly because that is not following the rules of decorum of the courtroom. So I just wanted you to watch that. About 5 more minutes. And because we are limited to time here today, I told everybody that when we were getting started this afternoon, but I don't think you were here yet. So I just want to make sure you understand where you are in time.
And here's the clash. The judge cuts her off and mutes her, reminding her to follow courtroom rules. It's a classic collision. A desperate, emotional defendant against the cold structure of courtroom decorum.
I just think it's a bad connection, Miss Lee, and I just want you to be aware of that. I think the louder you talk too, I think it's a little bit harder to hear you. We're all muted, and so I think if you talk in a normal voice, it comes over a little better. We don't hear you great, but I want you to finish up. You're not coming back. We're going to get this done. Ms. Racanelli, if there's gaps, you'll just need to say gaps because we're not going to stop for this. We're going to get to Miss Lee's end of her argument. I'm sorry, Miss Lee. We're just going to have to go with what we have. We can hear you. It's faint, and at times it's not clear, but I am getting the gist of it. It's just for the purposes of the record, I just want to let you know there may be gaps with what Ms. Racanelli is taking down. We're doing the best we can, but this is the best we can do. Keep going.
Okay. But again, like I said, she withheld information which caused a big issue. Issue turned into her issue. So basically, we never discussed my case at all. It was her issue the day before court. It was her issue during the whole proceeding. So we never ever discussed anything, and she can't even show proof that evidence is against her. So what I'm saying is, because evidence wasn't for everything that I'm discussing that I entered into this case, new case is new evidence because it was never entered in the last case. I never got the opportunity to enter.
She's not picking up anything. Whatever you did to your sound made it worse, not better. So I'm just telling you, can you go back to the other sound?
Okay.
Not well, but we're going to finish up, Miss Racanelli. We're just going to finish up. You're just going to need to take what you can take. Go ahead, Miss Lee.
Okay, basically, like I said, this is just a wrongful dismissal. The information was not given to me. Ms. Bose was not cited about it. I need her. She was not reprimanded either for withholding this information. This dismissal was just signed and done. I never even got a chance to argue, as you can see from the thread. That is the whole entire conversation. As you can see, nothing was mentioned. So therefore, everything that is in this case as of right now is valid and just. It's allowed. Because if it was never discussed, it wasn't part of that case.
Even with her microphone failing, Miss Lee keeps pushing, repeating that she never had her evidence heard. This isn't just legal argument anymore. It's someone begging to be acknowledged.
I am located in San Antonio.
And I'm just curious because I don't think it really matters. I'm going to tell you that in a minute. But how did these hearings ever get done by Zoom? How were these ever set by Zoom? Did you want Zoom? Because you're the one who's out of town.
I set this up for Zoom this time because I am out of town. But the first meeting was supposed to be in person. Ms. Bose knew that. The issue was it went to a Zoom because I had a park, and I told her, okay, I might need to go to a Zoom because I can't make it to Austin. Then at the last minute, I found a way. So I told her I can make it. But as far as I knew, it was supposed to be in person, which is what I requested from the beginning. But from the beginning, Ms. Post wanted it on Zoom. I was against Zoom because I am not.
The Zoom issue shows the human side of modern court. She admits she's old school and wanted to appear in person, but technical problems left her feeling manipulated. For her, Zoom isn't convenience. It's another barrier keeping her out.
About this, there are concepts at play here, Ms. Lee, that are difficult concepts sometimes, even for lawyers and judges, but there's an issue of plenary power and collateral attack and res judicata, and they mean things. And it means that the case that was originally brought to court was the case that actually is the proceeding that needs to be going forward. And that is the case where you need to look at if there is a way to overturn that judgment. But that is not what you did. And so in that regard, the motion to dismiss in this case is actually quite an easy decision because I only have one decision to make, and that's to grant the motion. Now, you, Ms. Lee, probably need to seek counsel or at least hit the law books, because that doesn't mean that you are precluded from any cause of action. It means you are precluded from this one. If you are correct and you didn't get notice and all these other things, then you need to figure out how to pursue that. But it is not what you have done, and the petition you have brought in this cause number is hereby dismissed, and I will sign on the order that Ms. Boast has provided to the court. Ms. Boast, did you load it up in the Zoom?
I emailed it to 201 submission.
We'll find it and we'll grant the motion to dismiss here. But at this time, I need to move on to the next cases. And then, again, Ms. Lee, I know that, this is not a solution that you are happy with, but you'll need to seek additional advice from a lawyer about whether or not you have any recourse for the GN 24 9532 matter. Because that is the matter that, preceded this one, and any issue in this case that you brought would be a collateral attack on that one. So,
Finally, the judge rules. Calm, firm, but absolute. Words like residential judicata and plenary power might sound technical, but the bottom line is simple. Her case is dismissed again. You can almost feel Miss Lee's heartbreak through the silence after the ruling.